So we decided we're going to do it not in alphabetical order, but we're going to do it in subject matter order, which just happens to be the same as alphabetical order. So we're going to start with Chris Ansel.
Okay. Thanks, Phil. Okay, there I am. Well, I want to say good morning because I'm coming from California. My body says good morning. I guess it's afternoon, though. So I want to start out with a trivia question. And I don't think anybody's going to know it. I thought about offering $5, but just in case there's one of you who has it, I'm not going to do that. I'm from California. Does anybody know the state reptile of California? State reptile of California. Any takers? Guesses? State reptile, the governor, right? Okay,
Salamander. You're going to say lawyer? You're going to say lawyer?
No, this is not a setup. This is true.
A skink.
Okay, I'm gonna know neither salamander nor skink. I'm going to give you a little bit more of a hint. It is also the state reptile of Nevada, which is important for my story. Does that help anyone? Okay, I should have offered the $5, I think, right? Because I could have got you. Well, can you see that? Anybody know what that is? That's the desert tortoise. And this one is at the Red Rock Conservation Area in Clark County, Nevada. And I'm going to use the desert tortoise to illustrate some of the ideas about collaborative governance that I want to talk about.
Hard shells, the main one.
Very hard shells.
Slow.
Very slow. No, that's not where I'm going with this. Yeah. Metaphors are powerful that way. In the late 1980s, the desert tortoise population was declining rapidly for a number of different reasons. There was a virus going around, but there was also declining habitat. And this led to a lawsuit, as you might expect. Environmentalists took the U.S. Fish and Wildlife Service to court, and the result was that the desert tortoise was listed as an endangered species in 1989. Okay. The problem that this is Red Rock Conservation Area. It is about 20 minutes from the Las Vegas Strip. And as you know, I think until recently, Las Vegas was the fastest growing city in the U.S. You can see some of the houses being built out on the edge of the desert. And the problem was, as you might expect, this listing of the desert tortoise meant that all this development, all these people, 6,000 people a month coming to Las Vegas, all of that was going to stop. Okay, so this was a kind of a drastic situation for the city of Las Vegas and the surrounding area. Well, it turns out that many of you probably know this better than I. The Endangered Species Act has a clause which allows exceptions to be made, allows you to develop some land if local landowners develop what's called a habitat conservation plan to mitigate the impacts of their development. So Clark County, where Las Vegas is located, took the lead in developing a habitat conservation plan, which they organized as a collaborative planning process. So I'm going to use this Clark County case to put some flesh on some general points about collaborative governance that I want to make. Okay. First of all, I'm mainly just basing the talk on an article I published with Allison Gash, I should say. And I also wanted to make a caveat here. I realize that this is an audience who knows a lot about this topic and probably a lot more than me and have probably practiced in the field on these issues and mediated disputes. So I feel like, well, maybe I'm giving you too simplistic of a story. So if I do that, I apologize. But what this research tried to do was it tried to take a series of cases that we found proliferating in the literature on collaborative governance, and we tried to figure out if we could generalize from those cases. We found in the end about 137 cases, or exactly 137 cases, of which Phil tells me I neglected to cite him, so I apologize for that, and anybody else I neglected to
Shows how open-minded I am, doesn't it?
So our idea was to find all the cases we could find at the time and to try to draw some generalizations about what the literature said. And specifically, we were trying to focus on pinpointing what were the factors that led to the success or failure of collaborative governance. Now, we collected cases from all over the world, so that was 137. Collected cases from all over the world, but most of them were U.S. cases. And we also collected cases from a number of different policy areas, education, health, you name it. But the largest number of cases came from natural resource management. And so the Clark County case, I think, is a good typical representation of many of the cases in our data set. One of our cases, just to give you a kind of idea what this 137 cases would be, was an article by Tom Riley, Collaboration in Action and Uncertain Process, in the journal Administration and Social Work. This is where I first encountered this case of Clark County. He talked about that case and a number of other cases in that article. I've since found a lot of other things written about Clark County, and that's what the talk is going to draw on. Okay, the first thing I want to do is start with, this is something that Phil really wants me to do, I think, and he has an amendment, I believe, to this. But I want to start with the definition we used in our study. We had to think about this a lot because we had to figure out what we were going to exclude from the study and what we were going to include. And we wanted to make sure we were roughly comparing similar kinds of beasts. And so we were pretty specific about what how we define collaborative governance. So let me just read it and then make a few points. Governing arrangement where one or more public agencies directly engage non-state stakeholders in a collective decision-making process that is formal, consensus-oriented, and deliberative. Formal means that collaboration is not just a private conversation between agencies and stakeholders, which of course we know are always there, but it's a publicly established process. Consensus-oriented means that the process seeks common ground between different stakeholders, often with opposing views. And deliberative means that there's a back and forth communication between stakeholders and agencies, and also, very importantly, directly between the stakeholders. Okay, so there's a little bit more to the definition, but that's kind of the key point. Okay, now the Clark County habitat planning process fits this definition, so it fits our case selection. And I'll just let you look at the groups that are on the steering committee while I take a drink. So this was, again, initiated by Clark County government agencies. They created a steering committee composed of agencies, many both federal, state, and local, and also non-state stakeholders, both industry groups, environmental groups, and a few more that I think may come on later. And this steering committee was responsible for guiding the collaborative planning process. The process was formal. There were regularly scheduled meetings, not hearings, meetings, and those meetings were open to the public. The meetings were very deliberative. Everyone could speak at the meetings. They really prioritized allowing everybody to get a chance to speak. The goal was to create a consensus plan that everyone could live with in the end. Okay, so it was consensus-oriented. Okay. Now, we summarize the findings of our research as a diagram. I'll fill it in a second. And here's a simplified version of it. And at the core of the diagram is the collaborative process itself. Can you see the blue? I probably shouldn't have used colors, but I was trying to help you keep clear about what I was talking about. So the collaborative process we saw as the core of collaborative governance, and this is when people are around the negotiating table talking to each other. So that's the collaborative process for us. And that's a process that directly affects outcomes. And I want to point out here that our study focused primarily on process outcomes. And let me just make that distinction. We focused on whether or not people successfully collaborated, and not, as in the Clark County case, whether they actually protected the turtle. Okay, this is an important distinction, and a difficulty with this work is that it's difficult to get at outcomes, and most of the literature is really focused on process outcomes, and that's what we did in the study. So our findings are based on that. Okay, we also identified 3 very general factors that we think are major variables affecting the success or failure of the collaborative process. The first is the institutional design of the collaboration, which is broadly the rules of the game under which collaboration proceeds. And the second is leadership, which is critical for guiding collaboration towards a successful, in a successful direction. And the last are we just call simply starting conditions, and those are the conditions that explain why people come to the table in the first place and what baggage they bring with them to the table. Okay, so I'm going to look at each of these 3 factors, and I'm going to start with starting conditions. So as you probably know, collaboration rarely starts on a blank slate. There's usually some kind of history of either conflict or cooperation, which basically, as we thought about it, sets the basic level of trust that stakeholders take to the negotiating table. In Clark County, the stakeholders were literally at war with each other, and I mean almost literally at war. The initial meetings were described as quote-unquote violent, and hard to believe, but for the first 2 years of meetings, they had to do weapons checks at the door to let people in. So this gives you, I think probably it would be an understatement to say that this was a low-trust situation. This was, this is Nevada. That's all I'll say. Okay, a second major issue. Oh, I didn't put that in. So I'm sorry. Prehistory of cooperation or conflict. Second important starting condition, power, resource, knowledge, asymmetries or imbalances among stakeholders. And this is a serious problem because weaker stakeholders will often fear domination by more powerful stakeholders, and this will often have an effect that either leads them for poor participation in at later stages, where they become very distrustful of what's happening, or simply just a kind of a decision not to participate in the first place. Okay, so in Clark County, the major disparity was that rural groups, these were basically 3 types of people: independent gold miners, small landowners, and off-road vehicle enthusiasts. They did not have the level of organization among themselves or knowledge of the ecological issues involved to participate on the same level as other stakeholders. And to remedy this, Clark County did a very smart thing, I think, which is that they hired a lawyer. I'm not sure that was the smart part of it, but they hired a lawyer to represent them, this group, this unrepresented group or poorly represented group, and provide them with ongoing assistance over a long period of time. So this was a way of empowering and kind of evening the playing field among these groups. Okay, both prior, the prehistory of cooperation or conflict and power and resource knowledge imbalances, they have a direct effect, as I've tried to suggest, on whether or not people want to participate in the first place, on the incentives they see to participate. And one of the lessons, however, that's kind of interesting about the Clark County case is that even in a very bitter atmosphere, this virtual war, the stakeholders still came to the table, and they did it because they had very strong incentives to do so. Okay, so even with deep conflicts, they came to the table, and that's kind of important to understand the story. So collaboration was in many ways the last option, the last good option for developers. They had already tried to get the endangered species listing dropped in court, and they weren't successful. They could have gone back to court, but it would have been a lengthy and probably very expensive process, and in the meantime, development would have been stopped. Now, environmentalists, they were in a little bit better position than the developers. They had gotten the endangered species, the desert tortoise, successfully listed. But on the other hand, if they were taken back to court, then they were concerned about trying to find quick solutions to habitat protection. And if they went back to court, it would be a long time before they actually got those protections realized. So they also had an incentive to participate. Both sides had an incentive to collaborate. Okay, so that's starting conditions. Let's move on to institutional design. And we found 4 core principles that we think are important, and the first 2 really have to be talked about together. First, the process has to be inclusive. It has to include at least all the major stakeholders. Keep forgetting, sorry. And the second thing is that the collaborative process has to be an exclusive forum where it has to be the exclusive forum where authoritative decisions get made. If not, what happens is that stakeholders who might see those alternative forums as being attractive, they'll defect from the process. So having what we call exclusive forum is quite important, we think. Now, obviously, stakeholders who are not included will try to seek out and create alternative forums, and there's a lot of examples of this. Because since they're not included, well, they might as well go out and try to figure out an alternative a forum to press their demands. So that's the way those 2 variables interact, I think. Now, the Clark County process was highly inclusive. The steering committee included all the major parties to the previous lawsuits, and the meetings, as I said, were open to the public. And at the time, Bruce Babbitt was Secretary of the Interior, and he very much was pushing for collaborative solutions, and he was attentive to what was going on in Clark County. And his support, people have suggested, was important for signaling that this was at least, maybe not the only game in town, but at least the most important game in town, this collaborative effort. Nevertheless, one important group decided not to participate, and that was the ranchers. And instead, they did pursue a legal strategy. That was a serious threat to the integrity of the process. In the end, though, the ranchers lost their court case, and it reinforced the importance of this collaborative forum. Okay, a third design principle is that there needs to be clear ground rules that everybody abides by. Among other things, I think there's a lot of reasons why clear ground rules matter, but among other things, they help to establish a civil process of debate and discussion. And remember, people are packing guns in these things, so you want to make sure that the discussion is civil and fruitful. The facilitator, who was quite good in this process, established 3 important ground rules. I think he probably had more, but these are the ones that have been talked about that I've found in the literature. First of all, no discussion of the validity of the Endangered Species Act. Okay, we're not going to go there. Second, no debate over the listing of the tortoise under the Endangered Species Act. Okay, we're not going to dredge that up. We're going to accept that as a starting point. And 3, not quite like a ground rule, but more like a principle, I suppose. Everyone had to agree to come to the table willing to give up something. So those were his 3 ground rules, and people found them to be successful. Okay, the last design principle is really kind of connected to that. It's process transparency. If the process is not transparent, you can imagine that then stakeholders will fear that the process is being manipulated. Weaker stakeholders in particular will see all kinds of conspiracies going on behind the scenes. So establishing high degree of process transparency is often very important for success. And again, the Clark County facilitator was very good at this, and he made that one of his major priorities. Okay, now we're going to move on to leadership. And, we just found over and over that the cases that we analyzed said leadership is important. This is kind of interesting. Political scientists kind of ignore leadership as a variable, although we know that it's always one of the most relevant variables. But anyway, we found that it was really important in this case. But we also found it's a very particular kind of leadership. It's one that excels at facilitating the process rather than directing it. So it's a certain kind of mediative or facilitative role that the leader has to take. Collaborative leadership is quite demanding, I think, because it requires that leaders develop respect from both sides of opposing stakeholders, and that's not always easy to do. At the same time, the leader has to empower weaker players to be able to participate at a level that makes them see their contributions as worthwhile. And doing all this, the leader also has to establish a sense of fair play, which is difficult when people are not happy with each other. So in this case, Clark County case, the facilitator, his name was Paul Selzer, and he was well known in the habitat conservation planning movement because he had done a very successful collaboration in Southern California. And apparently he was very good. Stakeholders said he had a knack for, quote-unquote, smoothing ruffled feathers and keeping the group, quote-unquote, focused on mutual gains. And one participant described him as a genius in not letting a single group or interest run away with the process. So that's leadership. Now let me go back to what I said was central, which is the collaborative process. Okay?
Yeah.
Okay. You've gotten people to the table. You've established a formal process. You have a good leader in place. Now what do you do? The first point I want to make, you got to start somewhere in this, even though, as you'll see, it's not a very linear process as we argue it. The first point is that collaborative governance has to build on face-to-face communication. And this, I don't think this is often stated, but I think that this is really a core principle. And I think that's important not only for the kind of rich communication you need to explore mutual gains, but it's also important for getting people past the kinds of stereotyping that they typically bring especially under conflictual situations, to the negotiating table. So one of the Clark County stakeholders describes the early stages of the Clark County process this way, which will give you an idea of the stereotyping. It was like being at a high school dance with all the beards and long hairs on one side and the suits and boots on the other. It gives you an image of what this was like in Nevada. So we also found that when conflict is high, some kind of remedial, we call it remedial trust building, is often necessary. So these are people that hate each other's guts. You got to get them past their stereotypes, and you got to get them to start trusting each other. Not an easy task. I can't say that the examples that I found of how they did build trust, they did, I think, successfully build trust, although maybe that's disputable in this case. How they did it is not perfectly clear to me, but just to give you a few examples of where I did find some indication in this direction. Stakeholders said that trust in Clark County was a byproduct of long meetings, which is not a hopeful thing, I suppose. But these long meetings always included meals and informal socializing kind of built into them. These meetings were all day kind of marathon affairs. So a number of people mentioned that these long meetings kind of over time built trust as a byproduct. They also did a kind of an interesting thing, which I've seen in other cases like this. They took the steering committee on field trips, and they took them out to see, specific tortoise habitat. And these field trips, being a little bit more informal, really created a little bit more of a social bond between people. So people felt like these field trips were an important way to build trust. Okay, now let's say you've got your trust going, and the next step that we found is that you really have to establish a commitment to the process, which may sound like this should come a lot earlier. A lot of stakeholders come to a collaborative process to basically protect their interests, and they're not yet convinced that they're really committed to the collaborative process. So going from being there to protect your interests to being committed, that's an important step. Now in Clark County, an important step was taken because the Southern Nevada Homeowners Association, a powerful group, they bought in early to the idea of collaboration, and they committed early, and they were serious about it, and this really led to a much more widely based commitment among a lot of different stakeholders on the process. But I also want to point out that commitment is also a psychological achievement. There's really a psychological shift that you can see happening in effective collaboration as people become committed. They don't always come committed, and then they become committed sometimes. And here's how Clark County stakeholder described it in this particular case. The most important achievement I saw was that a group of people walked into the room hating each other's guts and ready to slit each other's throats. And now if you were to come visit those meetings and say something against the plan, you're apt to get eaten by both sides. So that doesn't quite describe the shift, but it describes the results of the shift. Okay, now once you've got commitment, then you need shared understanding. Stakeholders have to develop a sense of what they can do and want to do together. And that doesn't mean that stakeholders come to agree on the same values. That's usually just, and at least in this kind of situation, is not going to happen. What it means is that they come to understand each other's perspectives. One stakeholder pointed out that people weren't converted by the process, but they did come to understand each other's quote-unquote bottom line, that's how he said it. And he said that this was important because, quote, subsequent discussion became less contentious and more productive, end quote. So shared understanding is important. Okay, finally, They're called intermediate outcomes here, but really much of the literature points to what people call small wins, or picking the low-hanging fruit. You've heard that term, as a means of reinforcing positive collaboration. Small successes help to build up to larger successes. In Clark County, they did this by developing a short-term plan that would operate until the long-term plan could be developed. The short-term plan linked development to protecting specific amounts of acreage of high-quality tortoise habitat. And what people found was that the success of this short-term plan really exceeded everybody's expectations and reinforced the commitment that people had to go back and construct a long-term planning process. 2 minutes. Perfect. Okay, let me conclude by pointing out that we have represented this as a cycle. Small successes lead to more effective communication, which leads to more trust, which encourages stronger commitment. Around and around is how we imagined it, and I think you find a lot of examples of this in the literature. In Clark County, there was evidence, I think, of this virtuous cycle, at least after the fact evidence. First, this short-term plan was successful, and that led to more trust and commitment to the process. Then the long-term plan was successful, and what I find really impressive is that eventually the same group embarked on a much more ambitious multi-species planning process, which was quite successful. So I'll conclude there. Thank you.
Hello. It's a privilege to be here and see so many friends and colleagues in the audience. And it was wonderful to see this rich meta-analysis of so many case studies that practitioners in the field have labored long and hard to develop, and other scholars, and it brought to mind the great value of this method that I think Gail Bingham demonstrated to all of us in her landmark book in the 1980s, bringing together a meta-analysis of over 200, I think, environmental conflict resolution and public policy conflict resolution cases, and reaching some of the same conclusions. I am not going to talk about data, though. Many of you may know me from work on evaluating dispute resolution processes and working with many of you in your programs. Instead, I am just very happy and feel very privileged to be here among such a rich mix of people, including many of the leaders of administrative law and who have worked so long and hard to develop the framework within which we are all working. And even though we've had some defections from the panels that Phil hoped we'd have, I keep thinking of that great speech in Henry V, right? We few, we happy few. And we'll long remember the dialogue we have today. I'm going to take a little bit of a different cut and put on my lawyer hat instead of my social scientist hat, and ask you to think about collaboration and governance more broadly than the definition that we just got, including a little bit more. And I'm not quite sure how this thing works. What, top button? No, top button turned it off. How do I?
Side buttons.
Side buttons. What side button? There is no side button.
Sorry. It's these two.
Ah, thank you. Yes, here we go.
Collaboration.
Thank you, Chris. The overview here is that we've seen a growing use of collaboration and governance, and it's described in terms that cross three fields, and these three fields are not always talking to each other, and to some degree they're saying some of the same things. All three fields involve voice. And these three fields are all bubbling up from civil society. We've had tremendous experimentation within agencies, and the three fields I would name deliberative democracy, or dialogue and deliberation, collaborative public management, or network governance, and then dispute resolution, variously called alternative dispute resolution, appropriate dispute resolution, administrative dispute resolution. And the argument I'm making here is that these three, if you look at things just in terms of where the experiments are happening, that these families of processes distribute themselves along a policy continuum, starting upstream with the legislative process and ending way downstream with the judicial process, and that there is some overlap in the middle, but that the legal infrastructure that we have to support this work does not map onto that policy continuum and onto these processes, that there's a mismatch, a fundamental mismatch between what our laws say about what agencies can do and what's happening in the policy continuum. So that means I think we may need new statutes, and I look forward to a conversation over these 2 days on what kinds of authority we may need and what limits on authority we may need. So starting with the three fields, this is the argument for a broader conception of the term collaborative governance, because the conception that we just saw includes organized stakeholders, but it doesn't identify the diffuse public as a potential source of collaboration. And in deliberative democracy, we do try to engage citizens and the diffuse public rather than simply organized stakeholders. A number of you are involved in experiments with citizen voice and civic engagement. And in a deliberative democracy model, we are trying to reach consensus in some models. We are trying to get people to understand each other and have this iterative communicative process in other models. But it involves the reasoned exchange of views on a policy issue. Then in the second area, collaborative public management, we do tend to have more in the way of organized stakeholders, and the literature on collaborative public and network governance is all over the map, because some authors will talk about networks only in terms of agency participants. So collaborative public management is collaboration among agencies, where others will identify networks that include public, private, and nonprofit players, but rarely do commentators talk about the role of the public in network governance. So we've got, what we're seeing is basically silos of literature. And then what's probably more familiar to most of you is the alternative or administrative dispute resolution literature, which would encompass environmental and public policy dispute resolution, and under the umbrella of which negotiated rulemaking has fallen in some past reviews. So if we look at how these things array themselves, just look at where the experiments are. My argument is, for the most part, we see dialogue and deliberation upstream in the legislative and quasi-legislative arena, collaborative public management mostly midstream and policy implementation as opposed to policy development, and then dispute resolution mostly downstream in terms of policy enforcement. But in midstream, there is actually overlap. So let me just show you this chart. I actually had two of these, one that had this basic framework, but in the bottom half had lists of the possible policy steps. We could break things out into maybe 15 policy steps. That's an arbitrary number. But things like, first of all, identifying whether we have a policy problem in the first instance, identifying possible solutions to that problem, prioritizing among solutions to that problem, selecting from among the priorities. You see, you could break down the process into a variety of steps. And what I would invite you to do is think about this as design space. President Kerwin invited us to think about whether we want collaborative governance to be seen in a systemic perspective or as an event, a one-off potentially, or ideally embedded process that's used at some point in the policy continuum. Well, I would vote for systemic, and that means if we think about this policy continuum, this is our design space. We may have a collaborative governance process that starts with some form of deliberative democracy or civic engagement, moves into a more narrowly focused stakeholder negotiation, and then builds into it enforcement mechanisms that include dispute resolution, mediation, potentially in disputes arising out of enforcement. And if you think about examples, I'm sure you will have many more that come to mind. I'll just give you one. The Centers for Disease Control, for example, are involved in a multifaceted process involving engaging citizens in focus groups and in dialogue around how we distribute a vaccine in the event of a pandemic. There have been related in deliberative democracy events in various states around just this issue, and I believe there was one recently in this area. So this is design space, and I've given you a bunch of examples. All of this is treated in much more detail in a paper that is posted to my SSRN site and BE Press site that you can download at will, and that is still undergoing revision. So if you have any suggestions or additions, things I didn't cite, please tell me, and I will add them in. So the upstream, midstream, downstream, and then the overlap, you'll see dialogue and deliberation, collaborative networks, and public policy ADR. The names vary, but what we're talking about in the middle there is implementing policy. And given that this picture of the continuum includes the legislative and the judicial branches, in this picture, negotiated rulemaking, I would put as midstream, as implementing the policy stated by Congress in legislation. All right, one example, I'm just going to give you a couple of examples, case examples. America Speaks is based here in D.C. and has gotten a lot of press, I think, has been involved in some very high-profile cases. And this would be an example of a process that I think should be included in our definition of collaborative governance. And yet, I think it's fair to say that it is not a process in which the people in the room are given decision-making power over a policy question. In the America Speaks model, you can have as many as in listening to the city over how to redevelop Ground Zero, for example. There were 5,000 people in a hotel room in New York arranged around tables of 8 to 10 with professional volunteer mediators from the dispute resolution community and facilitators from the public participation community. And these people at the tables had handheld digital voting devices with their demographic information programmed in. They deliberated from the bottom up. They came up with consensus at the table that was then sent wirelessly to a bank of computers. And in real time, qualitative research was done in real time with people from America Speaks and also people to keep them honest from the citizenry. And then these ideas were then projected around the room on giant screens, and people then had iterative voting. At the end of the day, the model has this design team that is analyzing all the comments develop a one-page report which includes broke it down by demographic group of a representative sample of the electorate, people's perspectives on this policy problem and what their priorities are and what they want to see as possible solutions. This then goes to the elected decision makers who can use that information in making decisions. So there's one model. Then you go to negotiated rulemaking. This audience, of course, doesn't need to be told about the steps of negotiated rulemaking, but we are looking at, of course, an identified group of up to 25 people at a table negotiating a draft regulation, which then will go to informal notice and comment. rulemaking with a professional facilitator, and using many of the techniques of dispute resolution to try to reach agreement, implementing legislative policy. Oops, I must have skipped. Yeah, okay. Now, the United States Institute for Environmental Conflict Resolution, a federal agency in Tucson, many of you have worked with the U.S. ICR in developing a national evaluation structure for cases that I would argue are collaborative governance cases. And this is a form of infrastructure for collaborative governance, and a special purpose authorization to an agency whose mission it is to help institutionalize collaborative governance. And it grew out of initially public policy dispute resolution and environmental mediation models, but they are now using the frame of collaborative governance to think about their work. And then downstream, you have executive branch use of mediation in anything that would otherwise be an enforcement action that would end up in adjudication, that could end up in litigation. So we have it both quasi-judicially in the executive branch, and then, of course, in the judicial branch. So those are just highlights of the design space. Now, here's the real heart of the problem. We have all of these experiments going on, but our existing legal infrastructure wasn't developed with these experiments in mind. And I think it's helpful to think of our existing legal infrastructure in historical perspective. I think what we've seen in administrative law are successive waves of lawmaking. There is an impulse to collaborate. There is an impulse to engage many voices in the policy process. Agencies keep finding it helpful, and then they find new ways to do it that are not contemplated by our law, and then we get this next round of legislation to try to capture the wisdom of our experience. So if you go arbitrarily, I've gone back to the beginning with the New Deal. But you could probably, and some people have gone back before that. And so my poster child is the Schechter poultry or sick chicken case, because it is a collaboration case. It is about taking a policy question, sending it under the National Industrial Recovery Act to a collaborative network of industry players, having them develop the regulations. But of course, there were problems, right? We didn't have transparency, we didn't have accountability. So that yields us the Administrative Procedure Act. Eventually, in the 1940s, we then have agencies trying to experiment with advisory committees because they find the advice useful. Well, it's not contemplated by the Administrative Procedure Act, so we end up with the Federal Advisory Committee Act to try to capture the learning and control what agencies are doing. We then get the impulse toward more citizen information, the Freedom of Information Act, and all of these are framed primarily in terms of an agency acting alone. And if you do a Lexis search in Title V, the word collaboration doesn't appear. So this whole notion of collaborative governance is outside the framework of the original vision behind our administrative laws. The problem is, of course, as we've seen, we've got policy problems that cross sectors and cross agency boundaries, and they're not only federal, they're state and local, they're not only public, they're private and nonprofit sectors, and we've got varying legal infrastructure that addresses them. So in terms of if again, thinking of our design space, we have good legal infrastructure, thanks to the people in this room. We have good legal infrastructure for dispute resolution. We've got the Negotiated Rulemaking Act. We've got the Administrative Dispute Resolution Act. They take very different approaches to authorizing agencies to use collaboration in governance. The Negotiated Rulemaking Act being very structured and having specific steps you have to follow to convene a group. And the Administrative Dispute Resolution Act, I like to compare to that last scene of 2010. remember where they say all these planets are yours, use them together, use them in peace? It's like it authorizes all these processes are yours. You can, in your discretion, see what fits where. And it's a non-exclusive list. So it's a broad authorization. Then we have other legal infrastructure in the form of agency-specific authorizations, for example, arbitration at the FDIC or Superfund mediation. But we also have agency-specific authorizations in agencies that are created to help us do this work, the USICR as one example, the Federal Mediation and Conciliation Service as another one. And then we have state equivalents of this kind of legal infrastructure, but that's not largely the focus of today. So we've also got excellent legal infrastructure now for dispute resolution in the courts, the ADR Act of 1998, for example. So that the judicial branch is taken care of. But what we don't have is legal infrastructure for collaborative public management, network governance, or dialogue and deliberation. What we have now doesn't match the processes that people are experimenting with. And these words, it's significant that these words don't appear in Title V. And this notion that we've got mandates for public participation is interesting, but in general, the phrase public participation is used and not defined. There are exceptions. For example, the U.S. Department of Transportation has regulations defining what it expects by way of public participation in developing state transportation plans. And those regs are broadly inclusive, and they do provide an opportunity for people to work together and try to reach consensus. So this notion of that, hold that thought, because I think that's an opportunity for us. The upstream uses are just simply not addressed by the Administrative Procedure Act. I'm trying to do this all in about 20 minutes so that we have time to discuss the problems. Now, this is where I actually, first of all, I invite, we talked about the possibility of taking questions after each of us talk for clarification, and I invite pushback on this, but I've started to collect stories from my colleagues in the field about where they run up against problems in the legal infrastructure for collaborative governance, where they find themselves being told either as agency counsel feeling that they cannot authorize a particular process for a particular purpose within their existing constraints, or they are people who are being told by agency counsel that there are problems with using a particular process. And a lot of these stories I'm getting from practitioners in the field, so they may be apocryphal, but for example, one agency had concerns, I am told, that it could not use an America Speaks model for civic engagement with thousands of people in the room to get input on agency rulemaking because there was no way to capture all the comments made in the room for purposes of keeping a record of comments for the rulemaking. There are stories that people are having trouble using blogs for comments on rulemaking because agency counsel has some concern that people making a comment on a blog may be responding to somebody else who made a comment on the blog and not actually intending that that comment be a comment on the rule itself. We've got concern in the network governance arena. These collaborative public management networks are forming, are doing work, but there is very little, with exceptions, of course, like the Center for Disease Control process, at least in the literature, there isn't a lot of conversation about how do we involve the public in the work, how do we do public participation in a network context? What is the role of public voice in a network governance? And then there are I'm sure, a myriad of other obstacles and barriers that we are only beginning to uncover. The National Academy of Public Administration has been doing this work specifically looking at Internet 2.0, but I would argue that the obstacles and barriers that we are uncovering in using the Internet to do collaborative governance are also obstacles and barriers for face-to-face collaboration, and that we need to look at both at the same time. Okay, so that then raises the question. It's possible we need, I would argue we do need, new legal infrastructure to facilitate collaborative governance. By suggesting this, I do not mean to take the position that all collaborative governance is good collaborative governance, that there isn't such a thing as bad process design, and I strongly believe we all need to do a better job of evaluating what it is we're doing so that we can learn. It's the only way we can learn, is if we start looking systematically at how various design choices affect the outcome, both in terms of the people who participated and also the ultimate policy outcome. But that said, if we don't have the legal authority to experiment, then we can't evaluate and we can't learn. So there are possible, taking a page from our administrative law mentors here in the room and looking at what we've done in the past, we could adapt the Administrative Dispute Resolution Act to cover to broadly authorize dialogue and deliberation. We could have a similar approach where we list all the processes that we want to allow agencies to experiment with. We could expand the role of our current dispute resolution specialists in the government, in the federal government, to encompass civic engagement. I believe that a number of you in the room are already doing that. You've already taken on that job. But this notion of broadening the mandate to encompass involving the diffuse public and not simply organized stakeholders or parties to a dispute, I think is something we need to think about. We do have issues around the accountability of networks and also their efficacy. There is some empirical work that suggests that when a network has a legal mandate to function, that it is both perceived as more legitimate and it gets a better job done. So this notion of having networks without a legal mandate, without authority to do what they want to do, is something I think we need to look more closely at. And how can we keep them within the rule of law? We're going to have to work through the issues of transparency and accountability in network governance. The Obama administration, and I was honored and privileged to be on a little task force with Carmen Sirianni and Kirk Emerson to develop white papers as part of the campaign, the Obama campaign on collaborative governance. And it was wonderful to see the executive memorandum issued the second day in office that encouraged agencies to look at their practices, look at ways they could make things more participatory, look at ways that they could collaborate. And I understand that there is work. Agencies are going to report back. There's going to be work on an executive order. However, the question remains, how far can an executive order go before it comes up against our legislated framework for collaboration and governance? So, oops. I lost that last slide. I don't know how to get it back. Okay. Well, I'll just tell you what's in it. Oh, there it is. It's back. Okay. So here's just a provocative possible approach. The words public participation are throughout the United States Code and the Code of Federal Regulations. I've had students pulling every occurrence of a variety of these terms and spreadsheeting them. And for the most part, the phrase public participation isn't defined. So that gives us a chance to say, let's have a Public Participation Act. Let's take the phrase public participation and define it for all purposes in the U.S. Code to include but not be limited to, and, give me the family of processes. all these different ways of engaging either citizens or stakeholders in this project of governance. And with that, do you want to open the floor? You want? Sure.
Can I ask a question?
Of course.
I'm going to ask a question, ex-rel you of Dan. I've recently, Dan Marcus's, I'm going to reveal actually a parentage of his. He's the guy that wrote the sentence in the Reg-Nag Act that said the standard of review is the same. So, but anyway, that gives him a long graybeard thing and something to atone for. But anyway, so my question is, Lisa raised a number of issues of which agencies are doing really stupid things on interpreting legal requirements.
I didn't say agencies were stupid. I never planned to say it. That was
I would say that was a quote that what she said they were stupid, but they're stupid. And I'm currently dealing with an agency that has made an interpretation of a bunch of the acts that she was talking about that are just dumb. I mean, just bad lawyering. So my question is there a way of raising that issue inside the government short of saying, so sue me? And then having the court do it. I mean, can you get something to OLC or to justice or appeal one of these stupid decisions higher than an agency? Yeah, in your former hat. What? Is that, so it requires a government official to ask OLC? Is that what? Okay. All right. Okay. End of my question. Long question, short answer.
We're supposed to have a reading. You have copies of your slides.
I would be happy to give a copy. Well, Phil has a copy of my slides, and you can post the slides anywhere you want for people to download. I don't care.
Right.
And the paper, again, is on the SSRN site. But where would you want to post the?
I think what we'll probably do is post them both on the University of Missouri CSDR, so you just go to Missouri Law School, and the Center for Rulemaking at AU. We'll post them both places, both the papers and the slides.
And we can put a
it'll probably
link.
be early next week before it happens. But.
Yeah, we can just link to the paper. The paper
Right.
is already on the web, freely downloadable at the
Well, but
Social Science Research
I
Network.
have it, and it's easy just to...
Yeah, okay.
So we do that the slides on through the
Yeah, we'll do that.
Other questions?
We have
Yes.
microphones, so we're going to try to record
I'm sorry.
this.
Okay, I'm sorry.
The great state of New York and Cornell University speak. What?
Well, now I'm nervous to ask my question.
No, don't speak.
I was curious about, you put ADR processes at the end, but yet mentioned mediation facilitation throughout the 3 stages. Are you using ADR exclusively as alternative to litigation, or where do you think mediation and facilitation fall in to the other stages?
Well, I think you've got collaborative process skills as one use of mediation and facilitation. And then you've got the notion of a fixed intervention in an overall design as another use of the phrase mediation. And so I think it can be used in 2 different ways. And we've had, of course, within the dispute resolution field, long debates and discussions about, well, what's conciliation, what's facilitation, what's mediation. So I guess I was using it loosely in 2 different ways. One, the formal named process that's an alternative to an adjudication at the agency level or an alternative to litigation. And also in the environmental context, where you're thinking about mediation of permitting, that's a formal use of the process. But upstream, in the context of something like an America Speaks model, they have mediators who are facilitating at the table level. Those communication skills that they're using, that are the heart of the practice skills, are going to be the same skills, even though the intervention itself might be called a 21st century America Speaks town meeting. I don't know if that's helpful, but that's an excellent point, and I should be clear on the language.
Kevin Bromberg, U.S. Small Business Administration, Office of Advocacy. Yes, we run into a lot of quote-unquote stupid agencies, too, and I get similar concerns about process, and, we can't do that legally because it has to be in the record. But so some of these concerns that I think you've heard raised about, these kind of processes are, we can't record what goes on in a big open meeting. But my reaction to that is we don't record lots of informal communications with agencies. We have a formal process called the APA where we respond to notice and comment. If the agency if the agency simply wants to acquire as input what it hears in all these informal settings, but doesn't rely on that input as it's as it came over informally, but only requires on stuff that it wants to capture formally in some way and put in the record, or rely on the written comments, since it always has the APA notice and comment requirement anyway, I don't understand the basis of their concern.
I agree with you, and I teach administrative law to my master's in public affairs students, and every year I give them each a state, and their job is to figure out, using their state APA, do they have legal authority to use dialogue and deliberation, negotiated rulemaking, or mediation. And about half the states they have express authority, but I've argued with them they can imply the authority to use processes in addition and before negotiated rulemaking. There's nothing inconsistent with the policy behind the statute in gathering additional public input. So I agree with you. Other questions? Do we have time for another? Yeah. Yes.
Rich Coleman from EPA. As an agency that is always sued, it doesn't matter what we do. We know that if we haven't done our job right, we get sued, even for you. Right. Often what our attorneys do is they look at the best defensible position at any given time to avoid being sued, so that when we get sued, we have the best opportunity to defend the decisions that we made. It doesn't always come out with things that everybody wants to hear, but it's often the most defensible. And you got to be inside the agency to see how often that happens and how that really pushes the decisions that we make.
Well, I think it's understandable because, think about the difference between the federal sector and the private sector. Counsel within, and I was an outside lawyer for public sector clients, dealing with inside lawyers in a former life. And you've got the Inspector General, right? You've got, if you think about it, a lot more bad things can happen if you say yes than if you say no. As opposed to people out there in the private market for legal services who see themselves as being paid to tell the client how to do what they want to do. So I think you've got different legal cultures inside agency counsel and then outside the government, and I think it's understandable, which is why we're having this conversation.
This could be a long conversation.
Yeah. With that, I think...
No, what, David, you want to do one?
I think it's interesting how the Obama efforts in their guidance and their executive orders are matching transparency with collaboration, because that's really what the problem is. How do we maintain the appropriate transparency of government and don't have things done without knowledge of the discussions that happened, at the same time allow for a much broader, less specifically aimed at representatives discussion? In the past, the APA is based on a representative of a group in discussions with the government, not the people in discussions with the government. And that's part of the history. How do we get past that but still provide for the transparency that's mandated?
Yeah.
And assumed, by citizens, that leads to most of the litigation that hits the process itself. It's a transparency issue that hits it.
Yeah. There's a fabulous book by Archon Fung, David Weil, and Mary Graham called Full Disclosure that talks about targeted transparency policies as a policy tool to reach a certain goal. And the example, they argue for a kind of collaborative approach to transparency. And I would argue this is also under the umbrella of collaborative governance. And the example they give is the SARS outbreak in the World and the World Health Organization. And this notion that under previous sets of rules, the World Health Organization could only intervene if it had a government report to them an outbreak. And China wasn't reporting the outbreak, but they were getting the information from people in China on cell phones and email. And so there was a change in rules to allow the World Health Organization to intervene based on that kind of information. Well, if you think about the potential for developing good information, again, going back to President Kerwin's opening remarks, that we have from people on the ground, there's got to be a way to put together transparency and collaboration. I don't think it's an either-or.
Good. Jeff?
Good afternoon, and it's great to see so many old friends here. Haven't seen some of my people here since I was back working at the Administrative Conference of the U.S., ACUS, many years ago. What I'm going to do is kind of do a sort of a Google Earth zoom down and talk about one technique, and we've heard something about it already, which is negotiated rulemaking. When Phil and the Administrative Conference of the U.S., ACUS, came up with the design for negotiated rulemaking, it was based on a couple of insights. First, that the usual process of written notice and comment rulemaking has an intrinsic weakness because stakeholders engaged in it rarely interact with each other or with the agency. Second, that in certain situations it is possible to bring together representatives of the agency and these various stakeholders to negotiate the text of a proposed rule. I would also add now a third consideration, that today the regular notice and comment rulemaking process has become rather discouraging to agency policymakers. The word we like to use for this is that it's become ossified. The amount of rulemaking has dropped significantly in the last few decades. Using some statistics compiled by the Competitive Enterprise Institute, in 2005, the government published 48% fewer final rules and 61% fewer proposed rules than they did in 1979. And even compared to the deregulatory Reagan administration in 1983, in 2005 there were 34% fewer final rules and 42% fewer proposed rules. So if the reg-neg process works to achieve consensus among the affected stakeholders, as it is designed to do, it could be a small antidote to that ossification problem as well. The agency should be able to issue its final rule more quickly. It should be significantly insulated from court challenges, and it should be able to implement the rule more smoothly. Moreover, even in those situations where it's difficult to achieve or there's an absence of consensus on a draft rule, the process may still be valuable as a means of better informing the agency as to the issues and the concerns of the affected interests. However, despite the fact that this sounds like such a great process, the use of reg-neg has waned in recent years, to the point that it is used half as often as it was used in the 1990s. And over half of the reg-negs undertaken in this century have been of the non-discretionary variety required by specific legislation. So I want to discuss some of the apparent reasons for this. Now, I don't think I have to describe how reg-neg works in this audience. Lisa just gave a snapshot of it. But one thing I should point out, I think, is that it's not designed to be used in every type of rulemaking. The Negotiated Rulemaking Act, or the NRA, kind of an unfortunate acronym there, was passed in 1990, and it set forth several criteria to be considered when an agency determines whether to use negotiated rulemaking. First, whether there are a limited number of identifiable interests that will be significantly affected by the rule. Second, whether a balanced committee can be convened that can adequately represent the various interests and negotiate in good faith to reach a consensus. Third, whether the negotiation process will not unreasonably delay issuance of the rule. Fourth, whether the agency has adequate resources to support the negotiating committee. And fifth, whether the agency, consistent with its legal obligations, will agree to use the committee consensus as the basis for its proposed rule. Now, several years after the passage of the NRA, President Clinton's Executive Order 12866 directed agencies to, quote, where appropriate, use consensual mechanisms for developing regulations, including negotiated rulemaking. And he followed that with a memorandum urging agencies to negotiate, don't dictate, and to expand substantially efforts to promote negotiated rulemaking. Well, this executive order remains in effect, though it is under review by the Obama administration. However, not much has happened to maintain executive branch interest in Reg-Neg, especially after ACUS went out of business in 1995. So to check whether my hunch that I had that there was less negotiated rulemaking going on in the 2000s than there was in the 1990s, I did some research in Westlaw's Federal Register database, and I searched the phrases Negotiated Rulemaking Committee or Negotiating Rulemaking Advisory Committee. I then tried to trace back the earliest indication of an intent to create each such committee. And I found that from the beginning of 1991, the year after the Negotiated Rulemaking Act was enacted, through the end of the decade, there were 63 separate such committees created, while from 2000 to December 1st, 2007, there were only 22. Thus, the number went from about 7 per year to about 3 per year. More tellingly, the number of statutorily mandated committees was only 23 of 63 in the 1990s, or about 36%, but 15 out of 22, 68%, in the most recent period. And yesterday I decided to update these figures through March 31st and found more of the same. There were 4 new Reg-Negs started in the 16 months since December 1st, 2007. 3 of them were statutorily mandated, and only 1 by the Department of Interior's Mineral Management Service was done without a statutory directive. They had done a regular rulemaking and had gotten some comments about some problems, some issues relating to a rulemaking on the valuation of oil on Indian territory, so they decided to voluntarily do a Reg-Neg. But the other 3 were the familiar Higher Education Act, No Child Left Behind Act, and Indian Housing Act required negotiated rulemakings. So what are the reasons for the waning of negotiated rulemaking? Well, I think there are several factors at play here. And first, and maybe most selfishly, I would have to mention the disbanding of ACUS in 1995. Congress had given ACUS a series of official responsibilities pertaining to the technique, to compile data, serve as a clearinghouse of information, report to Congress, provide training, and even pay the expenses of agencies in conducting Reg-Negs, including paying the expenses of the conveners, facilitators, and committee members. When ACUS lost its funding in 1995, this function, for all practical purposes, went unassigned. The second major factor is budgetary. There's no question that convening and organizing and conducting a Reg-Neg involves a greater cost than organizing a regular notice and comment process. In 1995, EPA did a report that analyzed the costs of doing its Reg-Negs and showed an average of $94,200 per Reg-Neg, or about $130,000 in today's dollars. This figure included all the costs of a Reg-Neg. Now, the upfront costs for doing a Reg-Neg are supposed to be more than canceled out by cost savings at the end of the proceeding, produced by having fewer comments and fewer challenges in court. But even if these positive changes or positive effects are present, they may still not be enough to persuade agency managers to voluntarily initiate a Reg-Neg. That's because budget officers have a very short time frame, short perspective. What resources do we have this fiscal year? We'll worry about next fiscal year, next year. And these costs that I've mentioned are going to be incurred at the front end. The savings are not only somewhat speculative, but they will be accrued next year. And some of them will be accrued by the Department of Justice if there's no litigation, not by the agency itself. So it's a little bit, and of course agency resources, as we know, have flatlined in recent years. Now, as Neil Kerwin mentioned, another budgetary issue concerns the demands that reg-negs place on the stakeholders. It can be expensive for them to attend a series of negotiating sessions, especially if you're talking about repeat players like environmental groups. So some of them might find it more economical to just file written comments. But these problems were not unanticipated. The Negotiated Rulemaking Act provides that an agency may pay for a committee member's reasonable travel and per diem expenses, expenses to obtain technical assistance, and a reasonable rate of compensation if such member certifies a lack of adequate financial resources to participate in the committee, and the agency determines that that participation is necessary to assure adequate representation. And of course, ACUS was authorized to provide funds, including gift funds that it received from foundations or anybody else who wanted to promote the use of reg-neg. And that's pretty much dried up. A third reason for reg-neg's travails, in my opinion, is that key staff in the Office of Information and Regulatory Affairs, OIRA, in OMB, have been unenthusiastic about it. As I mentioned, Executive Order 12866 is officially supportive of the reg-neg process. And the technique is not necessarily inconsistent with OIRA review of rules. After all, the agency is a party to the negotiations and can consult with OIRA throughout the process about the acceptability of the rule that's being negotiated. And OIRA can attend these negotiating sessions as well. But once a consensus has been reached on a proposed rule, it does become more problematic for OIRA to then seek changes in the proposed rule. They'll get met with the response, well, the group's already agreed to it. So it's a loss of leverage for OIRA. And I'll let Don Arbuckle speak for himself on this, but I've certainly talked to OIRA staff in the past who have shared with me their dislike for reg-neg. But I believe that OIRA should welcome a well-done negotiated rulemaking because the affected industry parties have, by definition, signed on to a successfully negotiated proposed rule. And if the final rule changes, then OMB review is still available. And OIRA has a lot on its plate anyway. Now, I should also point out that in some situations, the agency's own rule clearance process may create bigger problems. A case in point, this is one example, is EPA's most recent reg-neg. It's only one since in this century, which established a rule relating to the Superfund program. It's called the All Appropriate Inquiries Rule. And it has to do with giving landowners a sort of a pass from liability under the brownfields legislation. They have to show that they've made all appropriate inquiries. So what does that mean? So EPA conducted a negotiated rulemaking on this. And so they issued their proposed rule on August 26, 2004, but the preamble indicated that the Reg-Neg Committee had reached its consensus the previous December. So there was a 9-month delay there. Well, why was that? Well, there was a internal review. There was an office in EPA which, as part of its review, despite having attended the negotiating sessions, insisted on the preparation of a cost-benefit analysis, not only for the proposed rule, which obviously was required, but for all the alternative approaches, even though the group had already agreed on the approach it wanted. Once these analyses were finally completed, the proposed rule was sent over to OIRA, and they completed their review very expeditiously. The same sequence took place at the final rule stage. EPA received a total of 400 comments, 200 of which were supportive, and the rest were relatively minor. Yet EPA took 14 months to publish the final rule. Then they sent it to OIRA, and OIRA met its 90-day deadline for review. So, and I've heard a similar story about a reg neg at the USDA. The negotiations were completed expeditiously. The holdup was getting the rule approved by the departmental officials because it wasn't on the high priority list. So I don't think agency programs are likely to suggest doing a reg neg if the clearance offices are not willing to build a fast lane for their ultimate review. For reg neg to be worth the front-end costs, the agencies and OMB need to facilitate the back-end savings that the process is designed to produce. A fourth impediment is the applicability of the Federal Advisory Committee Act to the process. The NRA makes clear that FACA is broadly applicable to reg neg. And in most agencies, the FACA administrative office is divorced from the program offices, and it has its own bureaucratic tendencies. Hence, FACA's charter requirements may discourage agencies from undertaking reg negs. And this in turn has led to a related fifth reason for the demise of negotiated rulemaking, the emergence of what I call reg neg light. Of course, there's nothing wrong with agencies using other techniques other than formal negotiated rulemaking, quote unquote, to learn the views of affected stakeholders, and it may even be preferable when consensus seems impossible. And again, I point to EPA, which was once the government's leader in doing negotiated rulemakings. It's clearly moved away from doing that. And this is not happenstance. One of EPA's leading officers in the area wrote in 2001 that the agency's emphasis had shifted toward, quote, facilitation of public meetings and workshops. Now, I believe such meetings may be useful, but they're less likely to produce consensus-based rule texts. And another shortcut that some agencies feel might be attractive is to skimp on the convening and or facilitating functions, perhaps by using agency officers for this purpose rather than rather than people like Phil Harder. Now, in my opinion, this practice is penny wise and pound foolish because of the importance of laying the groundwork for a successful negotiation committee at the convening stage and the crucial role of the mediator during the negotiation phase. A sixth reason for the waning of reg neg may be the criticism by some respected scholars in the field of administrative law, even though I think they're in the minority. This criticism has two main tenets. The first one, led by my friend Professor William Funk, has suggested that reg neg leads agencies to too easily shirk their responsibilities to uphold the public interest by accepting the consensus rule, thus turning their regulatory mission to the regulated, sometimes also leading to results that might be outside the agency's jurisdiction or legislative authority. The second strain of criticism, led by Professor Coglanese, suggests that reg neg's purported savings of time and litigation costs are illusory. Phil's, and to my mind, has forcefully rebutted these concerns. But as for Bill Funk's concerns, I think they're rather theoretical, and that if the convening stage is done correctly, the right stakeholders and the agency representatives are all around the table. And if the agency's rule somehow strays away from its statutory authority, it can be challenged in court by an adversely affected person. And I think that even if Professor Coglanese is right that reg neg does take longer than paper rulemaking, which I don't concede, or if it does, it's because of some of these other factors, I think there's a definite benefit, hard to measure, in getting the buy-in of the stakeholders in the rulemaking and in the eventual implementation of the rule. So even if it's a longer process, I think it might be worth it. But perhaps for all of these six reasons, most agencies have stopped using reg neg voluntarily. Other than the one EPA reg neg that I just mentioned, only 4 agencies, Interior, Labor, Transportation, and the Postal Service, have voluntarily considered establishing reg neg committees, or established them, from 2000 to the present. 18 of the 26 reg neg committees were formed due to specific statutory mandate. 8 by the Department of Education, 3 by HUD, 2 by DOT, HHS, and Interior. And this statutory mandate for specific agency program reg negs, I think, can be problematic because in some cases it only serves to punt a non-negotiable problem from Congress to the agency. So in conclusion, while I don't discount the possibility of other types of agency facilitation of public meetings, as a useful technique, I think that the waning of real negotiated rulemaking is unfortunate. Not because it's a panacea, but because when it is used in a properly targeted way, it can be very effective. And I want to quote an article by someone I don't know, Daniel Selmy, who wrote about a California state reg neg. And he said that more importantly, for too long the debate over negotiated rulemaking has revolved around extreme conclusions about its benefits or failures. It is portrayed either as a panacea or as a totally misguided venture. In fact, it is neither. It will certainly not be a complete cure for administrative malaise. I wonder where they got that quote. And it will not be effective in many situations where the proposed rule affects a wide range of interests. It can, however, be quite useful in some instances. Accordingly, the expectation for regulatory negotiation needs to be recalibrated, and to be effective, its use must be targeted. So I think the federal government acutely needs creative solutions to regulatory problems, and negotiated rulemaking is one of the few quote-unquote regulatory reform initiatives that does not raise political hackles. And it has been shown to be of proven value in solving some knotty regulatory problems. So I think the White House should breathe new life into it by providing real support for it, not just lip service. The Congress should support agency use of the technique with funding, and they should only mandate it in specific programs in a discriminating way. And now that the administrative conference may be revived, it may be able to lend some needed encouragement and aid to the agencies in its use. So I'm not going to take any questions here because I know Rena is going to follow me, and she is a bit more skeptical than I am about reg neg. So we'll take some questions after she speaks.
Thank you.
Well, I was invited here. I actually called Jeff and I said, okay, so I get it. I've focused on this agenda and the people who will be speaking, and I'm the skunk. In fact, I'm the only skunk, from what I can tell. So let me lift my tail and spray you as best I can. First, to just say where I personally am coming from, and then what position or perspective I think I'm representing, because I think that might be useful. My experience with negotiated policy processes is mostly as a practitioner or an advocate. Although I'm very influenced by teaching negotiation to my law students, which I did for many years and enjoyed it a lot. The truth is that 90% of legal disputes, including all the ones we were talking about here, are settled. They don't go to trial. This is something that remains a mystery to most law students until they hit the real world. And my mission in life was to explain to them that the television shows showing the great summaries to the jury were, in fact, the exception, the narrow exception rather than the rule. But for these purposes today, I'm going to try, we've spent a lot of time talking about the taxonomy of collaborative government and negotiation. I'm going to try and focus back in on what I think Chris was talking about, which is formal processes where we say we're all going to sit down and try and negotiate a solution to some kind of dispute. And I think that there are three kinds. One is a sort of macro policy conversation. For example, Enterprise for the Environment, which tried to create a third generation of environmental law. This was chaired by Bill Ruckelshaus, the former administrator of EPA, and ended up running into a lot of problems because, to put it bluntly, the environmental groups walked. Second example is place-based negotiations, and I think this is what Chris was talking about in his Clark County discussion. I would suggest to you the entire Chesapeake Bay program is one big place-based negotiation, which never seems to come to an end, to some people's dismay. And the third is regulatory negotiations, and that was, I think that's what Jeff was talking about. My particular experience was with asbestos rulemaking at EPA. At the time, I represented the janitors, the Service Employees Union. So I had a perspective on that. Now, like any other negotiations, I think, and this is, I'm repeating what Chris said, was a few war stories mixed in. You need incentives and a deadline, and the incentives need to be very, very powerful. Otherwise, people are just going to fool around. You need to believe that either the law is going to be passed without you, and you're worried about taking your chances with the United States Congress. You are, in other words, a smart person who understands that that process can be very disconcerting. You need a deadline, so you need to believe whether this is actually take it to the bank belief or a perception that there is going to come an end where the decision is going to be seized from your hands. I think Chris was talking about that in Clark County. And you need to believe that the political and policy conditions are conducive for making these kinds of decisions. And to give you an example, I think there is a tremendous problem in the Chesapeake Bay program because lots of people think that farmers are not covered by the Clean Water Act. And because we cannot fix that problem, because there is a group of critical stakeholders who have no reason to come to the table under the law, it becomes very, very difficult to sort of advance the ball down the field with collaborative governance. So out of these two things, I would say, out of these conditions, I would say that two things are true. One is that collaboration without compulsion does not work. And I realize that's a pretty controversial statement, so I'm happy to be argued with. The other side of it is that I absolutely agree with some of the other speakers who have suggested that if people sit in a room long enough, even if they were toting their shotguns to begin with, they can reach agreement on just about anything. I've actually seen that happen. If you had told me when we started the Superfund Commission on Superfund negotiations and the law, that was back in 1995, the law hasn't been reauthorized since. This was the closest that we ever came. If you told me that environmentalists and the chemical industry and municipal governments and environmental justice representatives would be able to reach some kind of consensus, I would have laughed in your face, and yet we did, because there was a lot of sitting in the room until we came up with a solution. And it was also a very interesting experience because there were the chief executive officers of Fortune 100 companies, FMC and Amoco, and a Hispanic carpenter from New Mexico who had a site in his neighborhood. And all these people sat around until they were driving each other stark raving mad, and they actually managed to negotiate a consensus. So collaboration without compulsion doesn't work. If people sit together long enough, they can come to an agreement. I suppose that's somewhat optimistic. Another factor in all this, I think, is that there needs to be a way to level the playing field. And from the perspective of the public interest community, this is a huge problem. Phil mentioned it. I would just really like to shove it front and center for you. Most of these disputes are relatively difficult technically and scientifically, and citizens don't have expertise to deal with them. There was a moment in the Superfund negotiations, I'm sure after all these years no one will mind if I describe it, where a CEO turned to the Hispanic carpenter and said, how about you and I get together and we can deal with your site? And the man, who was basically had probably a high school education but was a very smart guy, said, I think I need EPA to come with me on that one. So people are going to be very reluctant to come to the table if they don't feel they can hold their own, either with government experts or with experts that are hired to advise them. And one of the critical problems with that is there isn't a large group of scientific and technical consultants that don't work for industry and can be hired by these kinds of groups. And there is no money to hire them. So it's a huge disincentive, a huge problem as a practical matter. Another way to level the playing field, which Phil also mentioned, and I want to push front and center again, is the issue of compensation for time. And I think probably the best example of that is another benighted instance of collaborative government, Project Excel, which was featured in the Clinton-Gore administration. It actually was a modest little EPA project that suddenly caught the attention of the White House and got caught up in the National Performance Review and became this huge cause célèbre. There were no upfront rules about it. It was basically if you have a factory anywhere in the United States and the environmental rules that govern it are frustrating you, bring your project to us and we will negotiate. We'll set up some citizens and we'll negotiate a solution. By the way, no national environmental groups, which immediately drove them berserk. And the local citizens were then engaged without any guidelines, without any parameters, in a process. I can remember interviewing one of them who was a software engineer. He was just volunteering. This was at an Intel plant in Arizona that cumulatively had the emissions of your typical gas station. This negotiation took 1,100 hours of this man's life over a year-long period. He was going to meetings starting at 7 in the evening and ending at 11:30 at night, 2 or 3 times a week. At the end of it, he decided that he wasn't happy with the way the consensus was moving, and the entire group turned around and, sort of beat him to death verbally. It was a terrible experience for him. And I've written about it if anybody's interested. But again, the leveling of the playing field, the parameters, the compulsion, the skilled facilitation, the avoidance of collaborative malpractice, which occurs very often, people have sort of alluded to it as the skunk, I get to call it what it is, causes major problems. The final thing is, of course, the ground rules that people have talked about, and I think there's been some very insightful comments made here today. In the 90s, I think we fooled around with consensus-based processes that are very hard to do unless you have the most brilliant facilitator in the world. And I've met people like you described, Chris, the guy that sort of, his name was John Ehrman, I think he's still in the business, but he could sort of have an instinct when you were about to wig out. I can remember him calling me up as I was getting a paper from the FMC guy, and he said, now, Rena, calm down, sit down, take a deep breath. What do you think Jerry is really trying to tell you? And that instinct for understanding when the parties were just misunderstanding each other and urging them to keep their eye on the big picture and to help them formulate what their response is these people are worth their weight in platinum, but they're relatively rare and they cannot function without upfront ground rules. You'd be surprised how many of these things get started in this kind of haphazard way without any discussion of, are we going to ultimately vote? What do we do if I have a minority position? When are the meetings going to be, and how do I avoid your wearing me out because you have superior sitting power? I could say that in a more crude way, but I won't. Are we going to keep these deliberations confidential? Who do I get to check with? What's the final product going to look like? What issues are on and off the table? All these kinds of things that I try so hard to teach my law student about any negotiation in this particular context are often, gone missing. I just recently, in the last 5 or 6 months, participated in a reg reform negotiating group that was convened by OMB Watch. And it had a bunch of people that were trying to come up with a consensus, and it had no ground rules up front. And I ended up, spending hours on it and just, being really distressed at the loss of the time. I ultimately decided I could not participate in the final report, although a lot of other people did. Takes a skill, takes your profession, that's all. I agree with that, absolutely. And finally, I think a critical component is that the agency, and we've discussed this too, I'm really just summarizing it from the perspective of an advocate, the agency has to be in a lead role. They have to have a strong role. They can't say, and this I think was a problem in the asbestos rulemaking, at least from my perception, whatever you guys decide we'll go along with. They have to say, we don't have statutory authority to do this. We do have statutory authority to do that. Here is what we want you to discuss. Here's the parameters of what we would like your advice on. And I actually think that if the agencies had credibility, they could get a lot of really useful work done talking only with industry people about the details of how a rule works to lower expenses and that kind of thing. We're a long way from that. I mean, environmentalists would be very distressed, or any other public interest group, if NHTSA sat down with the motor vehicle manufacturers or EPA sat down with the small chemical makers or something like that. And that is, I think, a major problem that impedes these kinds of things. And a big value of negotiated rulemaking is to get those details right so that the rules are less onerous, needlessly onerous. So to wrap up, thinking about all these conditions, I wanted to sort of pull the camera back and talk to you about what I think is going on in the real world right now that makes it very hard to get these conditions to apply in any particular situation. I think Jeff's talk was a very interesting insight into how much rulemaking we've been doing. Ossification, the economics of it. I think the economics of it are a very compelling argument for agencies. But there are some problems that are sort of out of our control and of a bigger picture nature that I'd just like to mention. The political atmosphere is absolutely dreadful. And I say this with the most respect. I mean, I'm sure it's not a surprise to you to hear me say that I admire our new president, and I'm glad he got elected. But we have come sort of crawling out of the most horrendous period in regulatory affairs in many, many a day. And I think that there is a sort of a residue of profound polarization and distrust. And I would use as an example climate change, which the President has said is a priority for him, and which the congressional leaderships has said that they want to do. And there are now, we're not just talking about how do we make it happen and disagreeing about the details. There is a solid group of people that are gearing up to fight anything. And that, in that atmosphere, I think it sort of trickles down, trickles up, and runs sideways and makes it very difficult to find consensus even on smaller things. The second thing, and I cannot emphasize this enough, is that especially there were a lot of people from agencies here. These agencies are hollow to a point that is takes your breath away. Jeff said they've been flatlined in recent years. I've actually assembled figures for the 5 health and safety ones, most prominent ones: Food and Drug Administration, Occupational Safety and Health, EPA, FDA, and the Consumer Product Safety Commission. And they haven't had a raise in real dollars since the mid-'80s. None of them have. Some of them are in even worse shape than that. The CPSC budget is about $80 million. $80 million. They have 15 inspectors to deal with all the imported goods we get in this country every day. OSHA, if their inspectors, which are significantly less in number than they were a few years ago, if they started inspecting every workplace under their jurisdiction, it would take them just once. Inspector visit every jurisdiction just once. It would take them 212 years to finish. EPA, the Government Accountability Office, just released a report that is sort of blood-curdling. If you're a nerd who likes these kinds of things, it's on their website, but they have serious doubt that EPA is going to be able to manage its existing responsibilities, much less the new ones in toxic chemicals, cleaning up the water, administering the Clean Air Act. So when you have a sort of civil service that is this close to the edge in terms of being able to manage, the perception, there's a tremendous amount of resistance at the idea of sitting in a room until everybody has talked themselves into consensus, because you can barely manage to do your day-to-day job. And until these agencies somehow recover and stop being sort of browbeaten, I think the atmosphere will not be great for collaborative government, and I think that's very unfortunate, but I would submit to you it's a big problem at this sort of underlying level. I mentioned that the logs have huge gaps. Most of the environmental laws have not been reauthorized in 20 years. We all know what's happening with food safety. You know what's happening with the peanut butter situation. That needs to be revisited. The Consumer Product Safety Commission was reauthorized because of Chinese toys, but nothing was ever done about the import problem. They were told to prepare a report and submit it in 3 years. And they'll probably be late and they'll probably get sued. As for the public interest community, and this is something that is widely known through the community, it may not have reached your attention. The foundations that support the policy groups that you need to have at the table in these things have lost an estimated $150 billion in the recent unpleasantness. There is an estimate that was prepared by a research group that is familiar with nonprofits that 1 million will go out of business before the recovery comes. So this is also a very, very difficult time to be going to a group like NRDC or even the Environmental Defense Fund or Consumers Union and saying, you know what, drop everything and please, you know, come to the table. We want to negotiate something with you. So I'm sorry to end on such a depressed note. I actually think that some of the most promising possibilities are the kind of thing that Chris mentioned in Clark County. I'm doing some work in the Chesapeake Bay now. I think there is a real sense everybody has in the Chesapeake Bay. If you're from this area, you know that the pollution is thought to be as bad as it's been. It basically hasn't changed in the last 20 years. And I think people are interested in trying to work out some kind of solution. I also think they feel that there's a little compulsion missing because the Chesapeake Bay program has no clout over any of the states that participate, and unless it can get some legislatively, it's going to be very hard to have that factor that pushes people to the table. But surely other things have not worked, and surely this is an alternative approach that people should look into. I'd be very happy to, consider any questions or attacks, and I'll sit down.
All right, questions? Mr. Auerbach. Should be next, so So this is a skunk of a different stripe who's about to talk here, right?
Thank you, Phil, for that kind introduction.
Where's the much more
This is Don Arbuckle, formerly of OIRA. I wanted to ask Chris how the dynamics worked when the committee was meeting with the public, presumably in the background. It was an open meeting, so there were other members of the public. What were the ground rules for their participation?
Well, I heard conflicting accounts in the accounts that I heard. One was that you had to be, one was that it was very inclusive, everybody could speak, and a lot of people did get up and speak. But I also heard that it took a pretty strong personality to get yourself up and speak, because it was a group of strong personalities. So you couldn't be what's the phrase? Fainting. Well, you can't be fainted hard to get up in that group. So the dynamics were open, and the facilitator did try to make room for the public to get up, but it was a contested and strong group of people, so it was difficult sometimes to
My second question is, how did the facilitator handle the fact that the ranchers were pursuing their own course of action? How did he keep the group together in spite of that?
I can't answer that because I don't know. It's not reported in any of the literature. But what I do know is that they did make serious efforts, outreach efforts to the ranchers. So there was a lot. They did a lot of public advertising to try to get the ranchers on board. But their group that represented them basically went the other way. So.
But can I have a follow-up to Don's question, if you know? There are kind of two models for public participation. One is everybody waits until the end, and you have very much like we're doing here. Now everybody's asking questions at once, or somebody can raise a question relevant to a particular point at the table at that time. Mm-hmm. So it's kind of two different approaches. Do you know which you followed?
I think it wasn't the hearing kind of this is more of a hearing kind of approach, right?
Well, it's a default for engaging the public in a lot of ways.
Yeah. I think it was more of an ongoing.
Okay, so if you have a point, jump in.
Jump in.
If you dare. Okay. Dan?
Just one question on the. You said that Clark County paid for or hired, you said, the lawyer for the rural interests. And I'm curious, did they pay for the lawyer and the rural interests hire the lawyer, or did Clark County select the lawyer for the rural interest? Do you know?
The Clark County selected the lawyer. And Clark County selected the lawyer.
I'm sorry. Cynthia, but before I do that, this is being broadcast live out to my bailiwick at the University of Missouri, who there may be people listening and may have questions. So after a few questions, get ready and holler out. So we'll see if anybody out there has questions. So Cynthia? And by the way, the folks in Missouri who are listening use your casebook. So, this is Cynthia Farina, who some of you growled at times.
Hi, Cynthia Farina from Cornell. I want to actually follow up on that question and ask more broadly about data. Several of you have raised the really important problem of equalizing resources, and Jeff, you refer to the provision in the Negotiated Rulemaking Act, which when I teach that, my students always ask, yeah, well, do they actually give people money? And I always say, geez, I don't know. That's a really good question. So I guess I'd like to know, what do we know about subsidizing certain groups at the table? Do we know much? Do we know how often, for example, it was used under the Negotiated Rulemaking Act? Because it seems to me how you do that is really a difficult problem. I assume it's not just throw money, although money is probably the essential first step.
I don't really know that much about it. I remember the very first negotiated rulemaking that Neil Eisner's office did on pilot rest periods. I'm pretty sure the department paid for some experts to come in to talk about the science of sleeping, and circadian rhythms and that sort of thing. Maybe David knows. David Pritzker was the person at ACUS who superintended this in the early days. Do you know? Yeah, ACUS didn't have any money, but under the Negotiated Rulemaking Act, agencies are supposed to be able to spend their own money. No.
Well, part of what happened, at least and I don't know whether there have been isolated instances in which agencies have funded, but the provision of the Negotiated Rulemaking Act is actually verbatim from the Federal Advisory Committee Act, which authorizes agencies to pay members of a Federal Advisory Committee a per diem not to exceed a GS-15. If one remembers, in the latter part of the Reagan administration, there was a concerted effort to defund the left, and a reinterpretation of FACA, which was to say that it was too late to issue a signing statement, but they issued a post-signing statement saying Congress didn't mean that and we ain't going to do it. And so with the funding of public interest groups under FACA also died the funding of public interest groups under REGNAG, and I can't think of any since then, and that's now, a long time ago, 16 years ago.
There's a couple of other examples. One is that under Superfund there were technical assistant grants made available, and those, you weren't allowed to spend those on lawyers, but you could spend them on technical experts, and I think that's how a lot of progress was made at some sites. The National Commission on Superfund had foundation funding, and people's transportation was paid, but they were not given any money for their time. Project Excel didn't compensate anybody for anything, as far as I can tell. So, the one thing I think we've never gotten over is the compensation for time, because that's a very tricky question. I mean, if you don't do it, then you have to have, if you want to involve working people, you have to do the meeting at night. And if you do it during the day, you're limiting yourselves to people who are retired or otherwise don't work. And there have been examples of getting expenses, travel expenses, but never that other critical.
But it strikes me that when ACUS gets on its feet again, this might be a useful research question to try to collect what we do know from some of these experiences, put it together, and try to go forward from there.
Right. There are two other quick answers, I think, just before we finish it, on some of the funding. Certainly foundation grants to participants has happened. And I have to admit to having money laundered a couple times in my past, where the industry participation thought that it was sufficiently important to engage in the negotiation as a form of education and frankly, of sharing the ideas, that they were willing to pay for the environmental groups to participate. In the early days, the environmentalists said, over my dead body, goddammit, I'm not going to accept your filthy money. And so they meant that they paid me and I paid them, although I think that we kind of hid, really, because we commingled it with foundation money. My impression, and just one final thing, my impression is that reluctance is not nearly as powerful as it once was, because they said, you're really buying something really fairly valuable, and we aren't, we're not caving in just because you're paying. So
That's where ACUS's authority to receive voluntary contributions under its statute from anybody for anything.
It wasn't a coincidence.
Came in handy, because that would help the so-called laundering of this money. I mean, the groups would give it to the administrative conference under its authority, and the administrative conference would devote it to negotiated rulemaking. But, we didn't really have a chance to set up a program for that.
Chuck Gordon, a retired regulatory attorney at OSHA. Just to answer your question, OSHA's never paid for anyone at NEGREGs. Now, dealing with unions and industry, they have probably more money than public industry. I don't know. But just to comment on several of the points that you two just made, money has not been a problem for OSHA, which has a very small regulatory budget, and you do save upfront money in the cost of preparing your regulatory analysis and writing your preamble, because you get a lot of data from the RegNeg. Yes, the agency has to have some clout to encourage people to engage in it, and the agency has to make clear that it will go ahead in a regular rulemaking if people don't negotiate. I was just involved in the Cranes NEGREG, which was very successful. Didn't take too long. It took about a year. But then the agency, through various bureaucratic fumbling, didn't take any action for 3 years after that. But that had nothing to do with the NEGREG process, which went efficiently and they reached agreement. I think the answer to that, frankly, is command emphasis. I worked for many assistant secretaries. I'm sure assistant administrators are the same. And if they want it done quicker, it'll get done quicker. And I assume changes in administration will affect that. It remains to be seen, but it can be done much quicker than that. And there's a tremendous political plus from a RegNeg, which is that you have to propose the agreed-upon regulatory text. And that saves the assistant secretary or administrator from a lot of criticism. You should have done it another way or a different way, or this is bad. You just say, well, I have to, by statute, propose it. You comment on whatever you want to comment, and we'll see, based on the comments, whether we should change it. Now, in terms of, we're reviewed both by the Small Business Administration under SBREFA and under OIRA, but they actually haven't held it up because they've stuck to their 90 days and 120 days, and that is a relatively small time frame in a rulemaking. But I'll tell you something, no agency is ever going to want to consult with OMB during the middle of it and keep them informed on every step. I mean, no agency would ever want to do it. They think the 90 days is enough at the end of the process, and
I hope you're coming tomorrow so you can fight me directly on that one. Can
I ask you a question? The Crane rule never came out, did it?
It's been proposed, and OSHA just completed hearings on it.
Well,
I attended.
So then the RegNeg, as I understand it, was completed in 2001.
94. No. That's all right, 2004. Yeah, the RegNeg was completed in 2004.
I mean, there are 84 people that die every year when cranes collapse.
Well, I mean, that was unfortunate. And there was no reason having to do with NEGREG that had anything to do with that delay.
What was the reason?
Well,
You're retired now, Chuck.
Yeah.
I think we all know.
I have to put it down to bureaucratic ineptitude. I don't want to be any more specific than that. It wasn't particularly political, and I think that can be overcome simply by command emphasis, by an assistant secretary saying.
You'll hear another side of the same story tomorrow with the same individuals.
Were other non-RegNeg rules also subject to similar delays?
Yes. All the non-NEGREG rules went slower.
What, both of them?
Both of them. Incidentally, several NEGREGs came out maritime that were probably under the radar in that period. without any problem. I do have one question, but I've talked too much, but if I may.
Go ahead, you got the mic, then we're going to pass it down.
Okay. One problem that did come up is the rules, which were very good to find consensus of 23 out of 25. But said if you were one of the two who didn't disagree on an issue, your reasons would be put in the preamble, but you were not supposed to publicly criticize the agency, although if you were a trade association, you could have a member. Now, during the rulemaking, one group that agreed to everything fairly heavily criticized the rule, and another group which disagreed on one fairly major issue heavily criticized the rule. And the question came up, what, if any, should the agency do about that? I was wondering what this group of experts has to say on that.
My own view is you put the agreement in the record, and if they don't sue, who cares? And if they do sue, let the Court of Appeals say this is a renege.
I think EPA allowed during the all-appropriate inquiry rulemaking, one of the groups did not want to sign on at the end, and they just kind of left the group at the very end and didn't sign.
And it's certainly not infrequent for a mediator to either persuade a party to withdraw or to file a conditional consensus or have a little chat with the president of the company. Are you aware what your director of safety is doing? Are you prepared to take a look? And seriously, I mean, some of those conversations are very interesting. Anyway, let's.
I'm going to make a couple of comments. First, what Chris was talking about in terms of creating consensus, I think is very important because at some point you want to get everybody in the room to more or less agree. But on the other hand, when an agency comes to the table, and I remember doing this with the old Thrift Depositor Protection Oversight Board when we were trying to create a multi-agency affordable housing program. We had 16 agencies in a room, and everybody had a different idea on how to do something. You have to have a very clear sense of what it is that you want to achieve out of that meeting. I was one who ran that meeting. Basically, we locked them into the room with a lot of coffee. And we eventually did come to an agreement in about 3/4 of a day. But I think that's very important. And Ray referenced that you do want to have some sense. Otherwise, you end up with the least common denominator, which is exactly the opposite of what it is that an agency ought to be trying to achieve. I think the other final piece I want to point out to is going back to the leadership, and again, Chris reflects on this. It's great to have a good facilitator, and they can do lots of things for you. You really need to have a strong, very, very strong leader who can also help facilitate. It comes back to Raina's point, is that you need a little compulsion there. Otherwise, you're going to wander around forever and ever and ever. Back to the affordable housing program we had at the Oversight Board. This was the body that oversaw the RTC. So as you can imagine, we had more than a few 100,000 houses that we needed to get rid of some kind of a way. We had to simply say to these 16 agencies, we want your housing in here. Fannie Mae, we want your stuff. Freddie Mac, we want your stuff. VA, we want your stuff. GSA, oh, you have stuff too. We want that as well. We're going to put it into a single unified program. And they were saying, well, you know, you're selling it too cheaply. And our reaction is, no, we're moving inventory. We need to get this stuff off the books. Otherwise, it's not doing anybody any good. It's not doing the government any good for us to be owning it. So let's move it. And the way you move it is with strong personality. And you might gather, since I have a little bit of a strong personality, I can. Jeff can tell you. And I think the other piece then is to be very clear on what outcome you want. Or at least the parameters of the outcome you want. Otherwise, as I said, you're going to be wandering around in this thing for more than a few years. And in Chris's whole point of having food and other things is great. We serve them a lot of donuts and coffee. Any other comments?
I'd like to come back to the Crane rule and the issue that was just raised in terms of the fact that there was some accusations that two of the participants from industry apparently didn't abide by the guidelines that had been established. My organization, which was not one of those two derelict organizations, did participate. And I'm concerned that when you establish, especially when you're dealing with trade associations, who are not going to be the decision makers in terms of the regulated community, you're raising an expectation which clearly can't be met. You're creating a significant due process issue, because if my organization has to commit up front with one individual that's going to be representing them in a negotiated rulemaking that they can't file comments later on, taking exception, they're denied the ability later to be able to challenge that in court. And I don't understand it. I don't see how that furthers or facilitates what you're really trying to do.
Aren't you talking about two different things here? I mean, there is a difference between a trade association signing on, which I would assume would require a decision of whatever their decision-making body is, whether the president's authorized to, or whether it's a committee, whether it's the board of directors. And then the second question is whether that's binding on any member.
Well, in this particular case, the accusation was that it was binding on the entire membership of the association.
Is that right, Chuck? Right. Right. I know no one that's ever...
Well,
Can I...
Well, I beg to differ with you. I was at the hearings where the moderator came and took exception by name to the organizations and wanted their comments, in effect, to be struck. So, you know, the issue is, what are you really trying to accomplish, and who are the entities that you have at the table? Because if you are dealing with a lot of these rules where you are going to be heavily dependent upon the participation of trade associations, you're not going to be able to get, in practical terms, the decision maker to be able to participate, or you're not going to be able to get the agreement that you need up front to commit to that type of an expectation.
No, you know, again, and I think we can spend some more time on this tomorrow. We'll have a lot more time. But almost always, in fact, every time I've ever seen it is of course you don't have the decision maker at the table any more than you have the decision maker for any other party at the table. So as you're getting close, there's a ratification process. And at least in the ones that I've ever seen, the ratification process does not include binding all the members. The more interesting question is it binding on a union because they have statutory binding authority? But in a trade association, there is a law review article that argues that you could do it, but I know of no one that has imposed it. Rena had one.
Yeah, I wanted to say, I think you're raising a pretty interesting question, and the way that the National Commission on Superfund operated, this is why we had CEOs. There was no trade association person. But the facilitators and the chair of the group spent an enormous amount of time up front picking the most influential company head and the heads of the environmental organizations, and somehow managed to persuade them to personally participate. So I think it's, just in general, I think it's a very interesting question, but there are many ways to handle it.
And I totally agree, and it's not to belabor this thing, but I think you have to look at the particular issues in the communities that are involved. In construction, for example, unlike in the chemical industry, where you have a fairly small population of chemical manufacturers, so it's much easier for them to be able to reach some agreement amongst themselves. You have a substantial small business community. So you don't have the ability to be able to have somebody come in from any organization and necessarily be able to speak on behalf of the group as a whole. I still think, and I don't want my comments to be misconstrued, I personally am a very strong proponent of negotiated rulemakings for many of the reasons that you all said. I think the record is substantially better at the end. I think that people are much better informed. But one of the downsides to what happened with this crane rule is the fact you had experts in crane operations who came but are not experts in terms of how you write regulations. So a lot of the criticism that has come since is not with respect to the concepts, but it's respect to the details that were worked out and how you translate that into regulatory speak. I'd love to, but unfortunately I've got to write something on the
I'm going to try and be coherent here. I'm listening to this on two levels, and what I'm hearing is what we lost with the administrative conference and the function of an entity to collect best practices and practice knowledge and generalize it and disseminate it among the folks who need it. Now, there are other entities that are trying to fill the gap, and a lot of what I'm hearing are things that could be addressed up front with good design practice and convening practice. Some of that information is on the website of the United States Institute for Environmental Conflict Resolution. They have also done this collaborative design of an evaluation project that many of the agencies, any federal agency that has any kind of environmental book of work. I think they've all signed on to a memorandum of understanding to participate in that. And part of that evaluation project includes things like capturing information about best practices, like did you do a conflict assessment, did you have ground rules. Another source for this accumulated wisdom is, interestingly, the IBM Center for the Business of Government has been commissioning all of these monographs from practitioners and academics to try to collect information and have it be accessible. All the monographs are freely downloadable. And the plug, Rosemary and O'Leary and I did one on managing conflicts in networks. And so this idea of bringing agencies together in a room, how do you structure that? You have to think through the governance issues of that. And then there's, of course, the interagency working group on ADR, which could take on this project of developing best practices and disseminating it.
I just wanted to, for those of you who don't know, the administrative conference was reauthorized and just recently was given some appropriations in the 2009 omnibus budget bill. And so, but there's nobody to receive it quite yet. So there are efforts underway to kind of stand up the administrative conference again. And if it's also funded in the 2010 President's budget, then I think it will actually spring back to life.
Okay, we have a gaggle of Assistant General Counsel for Regulation back here. And you're going to interplead between who goes first, or you?
Actually, I'll be a perfect facilitator and say I think everybody's really agreeing in what they're saying right now. I think the gentleman on my left makes a very, very good point. I'm from the Department of Transportation. I'm Neil Eisner. And about the fact that everybody, not just the agency, but especially the agency, have to know, going in, what is it you want to achieve? We had a union tell us that they saw the problems sitting through all the negotiations with trying to make everybody happy. They were happy with the compromise that was being worked out. They realized it was probably the best they could get, and it was a good balance. But they said a lot of our members won't like it. So we're not going to sign the document. When you put it out as a final rule, we will object, and that will be the last you will hear from us. And we said that's as good as consensus.
I've done that more than once.
That was a very contentious issue. And we've had variations of that. We've had people walk out during the negotiations because they couldn't get what they wanted, and they decided they weren't going to stay. They weren't going to see if the overall package could be better for them, even if they lost on this particular point. We wrote letters. We said, please come back. We want to continue negotiating. Committees on the Hill asked us what was going on. They would not come back. We did the best we could with all the data we got, and it was very, very helpful. And we put out what we thought was a better rule because of all the negotiations we had had. When they didn't get what they wanted on that particular point in the final rule, they went to the Hill to complain. The committee staff said, you were given a chance to negotiate. Why'd you walk out? So there are various forms of consensus. There are various things that people can get out of these negotiations. And you've got to know going in what it is you hope to achieve and what would be enough and what might not be enough.
And some of you will walk out showing Cynthia's ad law book.
So it's a very good thing that lawyers are so expensive then.
Right, thank you. Okay, I have a question to whether anybody at the University of Missouri has a question, and I have no idea whether we can hear it if they do. So. No questions. Clearly, students of mine.
You've already answered all of their questions, Phil. They have none at this point. There you go. Two observations. One is, you're right, the biggest issue is the how do you pay for people's times. EPA, over the years in a diminishing amount, has always found a way to cover the travel cost, has always found a way to cover the experts for the other side, hired by the other side, paid by somebody else. Not always the government, but it was always a matter of, it didn't matter who paid for it as long as they had a chance to select and control their own expert. We always find a way to do that. We have big trouble finding a way to pay their time because of various hundred reasons. And that's both, honestly, in the formal regnegs and the policy dialogues, which we've done many more of than formal regnegs.
Why is that, David? Why have you stopped doing so many regnegs?
But that's my second point. And this is somewhat of a skunk question from a huge supporter of regneg. Regneg will not happen because of the self-interest of the agency. And that's just the reality of things. And that's one of the problems with this discussion. On one level, we've been talking about why is it in the self-interest of the agency to do regneg. And that's the basis upon which the Regneg Act is passed. But, unless there is some way for the administration or government to change the culture of the expectation of how government is to practice, not whether it's in their self-interest to use regneg to do the old form of practice, we're not going to use regnegs. And honestly, and I would suggest that that's the reason why you're not seeing more regneg out of my agency, because we have been fighting internally with a number of people, Deb and myself and others, who understand this stuff and have been in one-on-one conversations with generations of managers, over why it's in their self-interest. Why it's in the agency's self-interest to use this stuff, and why it saves all the time, et cetera.
The information gathering is not enough?
No.
Are you coming back? Because this is the heart of much of what I'm going to be talking about tomorrow.
I'm just queuing this up for, this is something I really want to see discussed and focused on before the conference, because it is the nut. It's really the nut of why you're seeing this diminishing return. And the reason you've seen a couple of hits in my agency had nothing more to do with the fact that the culture of the individual manager in that office thought that was the way we should do things. And we really need to think that through while we're here. How do we create that culture that honestly doesn't deal with all the good reasons why it's in their self-interest?
Okay, break time. There's coffee outside, and then at quarter of we'll have the next panel. Very good.